Today, 6 legal battles that are shaping tech.
Free speech or censorship?
Copyright or fair use?
We're the judge and jury, and we will discuss, debate, and tell you what it all means. I'm Gene DeRose.
I'm Steve Rosenbaum, and this is Future Forward. Let's launch. We didn't start out to want to do a show about legal issues, but when we found 6 cases and 6 issues that are so interesting and topical and timely that we just decided, we would say this to our podcast listeners and viewers, like, don't tune out just because it's about lawyers.
No, there's a lot going on, and, collectively, these are a lot of strategic issues, and we really only go at one of the real big guys, but we'll kind of tag and untag Facebook and some of the bigger implications as we head into a kind of a legislative kind of year that may turn some corners.
So let's just give you the headlines, and then we'll go through the cases. Bird scooters, Fortnight, Netflix, Grindr, Prager University, and Meta. Those are our 6. So you can jump ahead if if you're not interested in, say, Grindr, for example.
Right. And I should say before we start, because the background is a little different. I'm on the road, so this is a hotel room in Colorado Springs, Colorado, not a secure location.
A fabulous town, a beautiful town. And by the way, you're going to get to do some skiing or no?
I'm not going to get to do some skiing, but I'm going to become a disc golf fanatic, and there are many courses in Colorado.
All right, so let's just start with bird scooters, because this is a good one. It begins with an article that was written by a fabulous, talented, long-standing internet leader, Cory, who I love, and wrote what I think, if you look at the article, and we'll put the links in the show notes. I mean, an article that, on the surface of it, seems fairly harmless. He said, hey, there's this software out there that allows you to turn bird scooters into basically personal scooters with a plug-and-play $30 conversion kit.
Right.
He didn't report, he reported this from another source. He published it, and Bird went after him, which I don't... Excuse me. It was so upsetting I sneezed. Bird sent him a cease and desist.
Yeah, and the backdrop of why they care, which has nothing to do with credibility of what they're doing, is, they're very sensitive to all the issues around danger and safety and recalls and legal issues around the use of these scooters. And so their antenna go up the minute anybody suggests doing something, rogue or independent or freelance. Now, that has nothing to do with anything, and it is even that harmless in that sense. But they kind of come off sounding like Donald Trump, I think. Let's attack the journalists as if that has anything to do with anything.
But the thing that I find fascinating is twofold. One, if you're going to send a cease and desist to any journalist and tell them to take down their accurate reporting, the answer is going to be no. That's right. Thing number one. And thing number two, if you had to pick the worst target for this kind of cease and desist letter, Cory Doctorow would be the worst target, because he has been forever involved in EFF and free speech and internet freedom. And there was no way that letter was going to do anything other than draw fire.
Right. The coda to that part of the story, which everyone should know, is that the Electronic Frontier Foundation promptly pounced on it from a legally threatening point of view, making it clear what kind of nonsense, this is. But look, I think
wait. But even better than that, the story was literally going to fly under radar. No one. It was a perfectly good boing story, but it wasn't going to be a mass media phenomenon story about a bunch of crappy scooters that you could just as easily buy at Walmart. But then by sending out the cease and desist, they blew the story up. That's what's so dumb.
Look, it is so colossally naive on so many levels. Naive about the way in which, the voice of respect to journalism you need to have, as well as really what is going to happen and the implications of acting in any way. And so, look, I think that, this is we'll get into some of these other ones where it's not journalists, it's company to company on patent infringement or trademark or things like that. But this really, it's a good softball to start out with, because there's no merit to this, but it's funny how it made news.
Just one more second on the scooter thing. I have to. So the thing, if you drill down into the story, that's interesting is what Cory is suggesting, or what he's reporting on, is that these scooters are getting picked up by cities that have and basically being put in an impound with tickets on them, and the company's not going to pick them up because they're so damn cheap that it's easier to let them rot in the impound, and the fines to collect them back would exceed the value of the scooter. So what this other writer that Cory reported on suggests is you could go to the auction at these impound lots and buy 100 of these scooters for $20. Yeah, and then break them all, and then jailbreak them essentially.
It's I used the word coda once, but it is a coda to what happens with fads in a way, right? It's like, it's not product recall. It's a glut of these things out there. The spinners. There's, I'm not sure really what would happen next, but it's kind of a bye-bye to their presence in the category regardless.
All right, so moving on from scooters, and we're all, so just to put a button on that, we totally support Cory. We think he's awesome. We think that the nice, crazy bird scooter people ought to just back the hell off, and Cory should keep reporting it. Like, we're 100% fans. So
right.
All right, number 2 though gets immediately more complicated. So you may have heard of this already, but we'll just recap it for you. A bunch of performers, of dancers, 3 of them in particular, are suing the Epic Games folks who run Fortnite because they're saying that Fortnite stole their dance moves.
For the so-called meme, what are they called? Memes? I can't remember what they're called.
Yeah, the little dancey things, right? Yeah.
Yeah. Well, they're the little electronic things you buy with your VIP bucks on Fortnite in order to celebrate, that don't really have anything functionally to do, but is actually a big part of their revenue flow. People spend money on these things, but they are, sometimes they're riffs on a wide range of things in the culture, visually, movement, whatever. And, we discussed this, I think, recently also around the idea of whether someone's tattoo is by an artist that can have copyright infringement. And I think this is a real murky area of internet, but broadly any kind of copyright, that it'll be interesting to see what happens.
So I'm going to dive in here and play Judge Rosenbaum. I think these cases are meritless.
I agree.
And I'll tell you why. Because if you read deep into the story, which took some slogging, I got to admit, the copyright law is actually really clear about the fact that dance moves are not protectable. That individual dance moves are not thought of on their own as choreography. Choreography is protectable. So a ballet or a piece of modern dance is protectable. But an individual move is, at least as the copyright law currently exists, clearly not protectable. So I don't know. It's like the difference between a song and a note or a riff.
Yeah, I guess so. I mean, to me, choreography and dance moves sound like the same thing, but I'm probably naive in the category. And
well, look, I'm showing as we speak. I'm showing for those of you who are watching the video, I'm showing the backpack kid move, which is basically his arms going back and forth. I mean,
right. So choreography it's like the difference between a book and a sentence, or a chapter and a sentence or something. It's a little riff on something when you just say a move. And I agree on that sense. I think the bigger question is going to be, are other types of digital little widgets copyright protectable or not? And I think the answer is yes.
I want to protect the phrase "let's launch." I think we should own that phrase.
Well, I went through a battle over the word want. So
Over the
I'm
word
not sure
what?
we over want. When I did this app like
Oh.
7 or 8 years ago, we got a challenge, and we ended up having a coexistence settlement that was fine. But ours was want with an exclamation point. Look, I think that there are a lot of hard edges and a lot of precedent on this stuff, but we're going to see over time, especially in the kind of riffer ecosystem that we're in, where copycats and imitations, and a lot of them are tributes, but it's not completely defined.
All right. So number two, we're going to say, we're moving on from that lawsuit. By the way, I assume the Epic Games guys, when they made the decision to not license these moves, went through their legal process and determined that they were in the right. So we'll see how that ends up. But now let's move on to Netflix, because this one gets more complicated. So Netflix is being sued by the Choose Your Own Adventure folks over the Black Mirror episode Bandersnatch.
Right, which, so people know, has interactive choose your ending, windy paths, unlike the rest of the Black Mirror series.
Now I was going to write this one off as well. I was going to give this a great big thumbs down. Judge Rosenbaum says, throw him out of court. But then it turns out that Netflix has been negotiating with the Choose Your Own Adventure publishers for a couple of years to try and license that phrase.
Right, up until like a year ago, and then they licensed something else. And the part that they're most upset about, that's the focus, is that they use the term, oh, is this a choose your own adventure kind of thing, in the script of the actual show. And so the question is, were they referencing a brand, or were they just talking generically? And does it matter, since what we know about them is that they were coveting this software?
So I'm going to put this one in the pretty dumb category. Like,
done by Netflix.
What?
Done by Netflix, right?
Yeah, dumb, because if you know that you've negotiated, like, presumably they negotiated with the publisher and were not able to come up with terms that were comfortable. So the publisher wanted $1 billion and Netflix offered 50 cents, and they parted company after, a bunch of rounds of negotiation. Why someone didn't see that script and go, we probably ought to take that phrase out. Like,
see that right, exactly. It just seems like it's a little mistake. They invited the problem.
Yes.
Because technically, I'm not sure. It's unclear what the deal was that they were even going to do in the first place. Was it a marketing arrangement? Was it, are they really going to use a lot of the software? These things it's really basic. It's branch tree, like, Choose Your Own Adventure doesn't own the choreography, as it were, of that particular approach to things.
But if I were the executive and this crossed my desk, I would cross out Choose Your Own Adventure, and I'd write pick your own ending, and I would circle out in a red pen and send it back, and the case would have gone away.
Yeah, I mean, look, I'm hoping that that's what it is, and because they screwed up, they have to wipe it from the video and all future uses. They have to pay a settlement fee or whatever else. But I'm assuming this isn't about Choose Your Own Adventure kind of proprietarily owning these kinds of applications.
All right, so now we're on to number 4. This one promises to be maybe the most complicated of the 6 cases that we're going to touch on. Having never used Grindr, I'm just going to say I don't know the software, but this is actually a really good, interesting, complicated case. This is a user of Grindr says that his ex-boyfriend used the software to encourage random strangers to show up at his place of employment and hit on him.
Right. Well, and an ex was able to basically stalk him successfully through that, approach for a long time, despite claims that it needs to stop. And look, what was the implication of the article that we're sourcing, and arguably the legal strategy of those claiming that Grindr needs to change its software. It kind of goes right to a broad set of things that are not unlike Facebook and social media and everything else. What degree of responsibility do they have in kind of areas out at the edges of what their applications can do? If somebody repurposes something in there to do something deviant or whatever else, where does the responsibility of the network owner, the software owner, end? And are they allowed to wash their hands of things?
So here's the quote from the lawyer that has everyone in the tech community kind of freaked out. The quote reads, "Grindr has created a defective product," said the lawyer. "It was very foreseeable that their product could be used this way." So product liability against a software company is a big case if they get some traction.
And honestly, I think it has some merit. It doesn't mean that it's going to be universal, but it is true that if there's it also depends. It's one of those, what is the meaning of because, what do they mean by flaw, and how much of it is a product related kind of functional flaw, and how much of it is an oversight of inevitable processes and behaviors, right? And I think that they're trying to claim it is a functional flaw in how it works, but I'm not sure how they correct it.
So let's just say that Grindr says, "Look, we'll settle, and here's here's $10,000 and a Grindr cigarette lighter and a hat." Like, I would presume the next lawsuit about identity theft and misrepresentation would be pointed at Facebook.
I think there's no doubt about it. And honestly, it's a real question. A lot of these social networks, for instance, have a rule where you can only use your phone number as a way of signing up once. And if you switch it, and I made this mistake, I actually set my 87-year-old father up on Facebook last week. And because we needed the fail-safe, I put in my cell phone number. And then I got a message the next day telling me that my personal account, my account, has now had my phone number removed from it.
Ooh.
Isn't that interesting? But look, I think that, there's the product scope and then there's this identity issue. But Facebook, honestly, a lot of these things, you can fool the system and have multiple accounts. And that's okay if you're kind of toggling between business uses on Twitter, up to a point. But if you're using it to misrepresent, it's a gray area. Who's to say what the difference is?
Can I confess one right here?
Yeah.
Do you have more than one Open Table account?
I don't have more than one Open Table account, but I have more than a lot of other accounts.
I have four.
Oh, so you can compete with yourself?
No, because there's a table, you want to go to this restaurant, but then you have to ask the other people that you're meeting if that's a good restaurant. So you make like 2 or 3, and then I cancel the ones I'm not using. I never leave the restaurant with a reservation. I'm not going to, but I have 2 restaurant reservations at the same time.
Well, look, I'm getting intrigued by the whole idea of identity as it relates to this, separate from the sort of product liability thing, because I'm not sure there's ever a way to resolve. There are legitimate reasons to have multiple identities and multiple presences on these social networks, and then there are illegitimate reasons, and I'm not sure you can mark out the difference between the two.
All right. We're on case 4. Let's move to case 5. By the way, I think you're doing an excellent job as Judge DeRose. We should have gotten you robes.
Judge DeRose.
So let's go to this Prager thing.
Okay.
So Prager University is, first of all, a little bit of a setup. Prager University is theoretically run by what's his name, Dennis Prager, but it's really not. He's kind of the front guy, and it's the article that we pulled, no surprise, is from Fox News and suggests that Prager is just this kind of even-tempered journalist character, but it is fairly hard-right extremist material, and university is completely a misnomer because it's not a university of anything.
No, it's closer to like a master class kind of thing in structure, in that it offers up videos, but they're highly polemical and far right of the kind of family and religious right persuasion. Although in the video, Prager does claim that Alan Dershowitz is one of his people, and they have 4 Pulitzer Prize winners who do the lectures and whatever. But what he's suggesting is that there's a liberal bias among Google, and he kind of almost dots manifest in YouTube in taking down obvious right favoritism, and they didn't even actually get taken down. What you need to understand, maybe you know this or don't, what happens is if you put on a certain kind of parental privacy software, or don't want to see porn, or don't want to see extreme material, that's when it gets shut down.
And I think it just flags it. I think it's all that Prager doesn't even want to be flagged.
And as they start describing it, it reminded me of what you and I talked about 7 or 8 months ago, which happened to us when we tried to advertise once or twice on Facebook, which is that we kind of got swept into a broader political, we're just going to play it safe game by Facebook or Google or whomever else. I find fault on both sides. I sentence both to death because honestly, it isn't necessarily fair of YouTube to have the kind of extreme material that it lets have on, and then not have other things. I guarantee you, extreme liberal things were flagged as well.
Yeah, I don't know enough about the case to know. I mean, look, if you're Prager and you're trying to get attention, it is essentially suing YouTube, Google is as good a way to kind of, wave a red flag and get all your conservative commentators to, as we're speaking, I'm showing a clip from Fox and Friends, and here's Prager getting a little bit of mass media airtime promoting it.
It's promotion. It was more than anything, it comes out as a like almost infomercial, shamelessly supported by Fox News. And again, they're just kind of tweaking people and inspiring more downloads. It's a little like the good version of playing the media, unlike the scooter guys.
Yeah, I mean, I guess at the end of the day, the thing I don't know the answer to is, do we now just live in a world in which, could we call this show Gene and Steve University? And could we, maybe we should change the name, and every week we'll teach a course in something that we're experts in. And by the way, we'll even give credits. You can get a diploma.
Right. And we all know about Trump University. And look, I think if there's
well played.
If there's fraud or the threat of fraud in that context of something like university, and you're paying for something, that's a legitimate thing. I guess I was trying to make space between free speech in general, 1, 2, this kind of university product fraud kind of thing, and then kind of the third side, which is the social network's responsibility to check things for veracity. Right? I mean, this is not so unrelated in some ways to pulling down fake news, or not pulling down fake news, because I do feel like what is the basis for calling something meritless or full of lies or misrepresentation?
All right, so let's move on to the last one. This is case number 6. And it's partly a legal story and partly, a story about a company that so those of you who follow me and read me in various places, I've been following and involved with this product Meta, which is a form of augmented reality glasses and an operating system, for a couple of years. I liked the CEO and founder. I liked the product. I liked what they were trying to do. And they were sued in a patent infringement lawsuit that happened to come right during the time that they were out raising money, and they needed to raise money. With caveat here, the AR VR space has shifted from being this big consumer play to, at least in this current incarnation, being more of a of a workplace, teach people, installers of a certain product, how to put the right pieces together. It's a little more commercial and a little less of a big consumer play, at least right now.
Yeah. Even industrial.
Yeah.
Yeah.
And certainly sidebar story, but coming out of CES this year, not clear that AR VR made any big strides forward.
Right. As we said last week.
But Meta was a cool company with a real vision, and the question is, does a patent suit, if it turns out to be meritless, which we will never know, does a patent suit landing on your desk when the thing about investors is they just don't need hair on the deal. They just don't need it.
No.
So I this particular case worries me because if we're gonna if at the end of the day Meta's problems, and I don't know enough about what's going on with the company, frankly, at this point. So maybe the patent case wasn't the final nail in the coffin, but it certainly feels like it was.
Yeah. Well, and look, the history before the .com era was that, and before which was the rebirth of what startup companies are all about, was a shift into companies being sort of public and transparent from day one, versus consumers don't know what's going on except what they buy on shelves. That's the old way of which things work. So I think the hazards of that space is that you kind of get what you ask for, and it can be PR damage by a competitor too. Someone could announce that they are now moved into first place over the other company just as they're raising money. There are perils here. Now, the potentially illegal merits of filing and making a hullabaloo over a meritless lawsuit right at a certain time, that maybe has a legal path on it. That's something different. But I unless we found that out, it's just unfortunately insult to injury at a bad time.
All right, so we have just a few minutes left. So let's do one last thing. So last week we got out ahead, and we kind of gave our early sense of where CES was going to be. Now we're at the end of a week of consumer electronics. Any sense that we missed anything?
Not a ton. I think that the stuff that's happening, again, there's the nuts and bolts of CES, and then there's did something succeed in making a sexy splash, which is a kind of a different plane of activity. And, really hasn't been anything. It's the ongoing story of a bunch of things. But I'll give you an example of something that I think is unsexy that, is a play in the market. I just got talked into, when I was having my teeth cleaned, getting an electric toothbrush by my dentist. And, I went home and I set it up with Bluetooth, and it's tracking things, and it's timing me, and it's giving me warnings. And, and I went and read up a little about it because I had heard about it. And that's a legitimate tech product category in the home that's started to really transform a reasonably small industry, and it's unsexy. But I think there's a lot of stuff like that going on.
How many USB charging devices do you have on your bathroom sink?
Oh man, I only have two because I don't use a few things that I might use, like the weight managing and a few other things. But that's a really good question. I
have four, and I'm not going to lie. I was looking at the mess of cables and plugs and thinking, this is a problem somebody should solve. Now, maybe it's just because we haven't gotten to wireless charging yet. Maybe it all goes wireless and it's a charging pad, which would be nice.
Technically, I don't really understand how wireless charging works, but I'll give you a little pearl to end on, at least from my side. As I was moving my daughter into college yesterday, their spanking new, she's starting second semester, freshman year, their spanking new dorm room has a microwave there, and the microwave has 4 USB ports in it. So you can charge your devices in the short amount of space there. And you know what? That's kind of cool. why not? You know what? I run out of those bricks all the time.
That's very funny. All right, well, we are out of time. So 6 lawsuits. We'll track them. We'll tell you what we find out about them as they go forward.
Yep.
Next week, more Future Forward. No more lawyers, we promise. We'll be back to cool new stuff. Have a good week.
Onward.